Colorado Real Estate Exams Questions. Question 1. Jamie Imani passed one portion of the Colorado broker exam and delays the application. How long is that passing score accepted for licensing purposes? Option A, 6 months from the registration date. Option B, 1 year from the date that exam portion was passed. Option C, 2 full calendar years after testing. Option D, indefinitely with continuing education. The correct answer is option B, 1 year from the date that exam portion was passed. Colorado exam results are accepted for 1 year from the date each portion is passed. 6 months is too short for the score minus validity rule, 2 years is too long, and continuing education does not make an expired exam score permanent. Question 2. Marlo Novak wants a clear passing target for the national broker portion. Which standard matches the candidate bulletin? Option A, 53 correct answers out of 74 national questions. Option B is 74 correct answers out of 80 national questions. Option C, 60 correct answers out of 80 national questions. Option D, 60 correct answers out of 74 state questions. The correct answer is option C, 60 correct answers out of 80 national questions. The national portion uses 80 questions with 60 correct answers as the passing standard. 50-3 out of 70-4 belongs to the state portion, 70-4 out of 80 is above the listed standard, and 60 out of 70-4 mixes the two portions. Question 3. A complaint claims that Casey Jones mishandled documents in a suburban rental house transaction. Which authority can investigate Colorado broker license law violations? Option A, the county assessor because the property has a taxable value. Option B, the buyer's lender because financing was involved. Option C, a home warranty company because repairs may be needed. Option D, the Colorado Real Estate Commission through its regulatory authority. The correct answer is option D, the Colorado Real Estate Commission through its regulatory authority. The Colorado Real Estate Commission regulates broker conduct and can investigate license law violations. Assessors value property for taxes, lenders underwrite loans, and warranty companies provide repair-related coverage rather than license discipline.
Stressed about your TSN exam? We can take TSN exam for you remotely and undetected. We always guarantee a pass and payments only after results. To send us an email, scan the code or tap the link in the description and let's get it done.
Question 4. Rowan Owens becomes the employing broker for a Castle Rock office with several affiliated brokers. Which responsibility best fits that role? Option A is supervising affiliated brokers, teams, assistants, records, advertising, and office policy compliance. Option B, guaranteeing every buyer's loan approval. Option C, setting county property tax rates. Option D, issuing building permits for renovated homes. The correct answer is option A, supervising affiliated brokers, teams, assistants, records, advertising, and office policy compliance. An employing broker is responsible for supervision and brokerage compliance systems. Loan approvals are lender decisions, property tax rates are government matters, and building permits come from local building departments. Question 5. Sage Kim helps a buyer and seller complete a ski-area condo sale without advocating for either side. Which Colorado brokerage relationship best describes that neutral assistance? Option A, dual agency relationship. Option B, a transaction-broker relationship. Option C, Suba-Jenki relationship for the buyer. Option D, power of attorney relationship. The correct answer is option B, transaction-broker relationship. A transaction-broker assists with the transaction without becoming an advocate for either party. Dual agency is not the proper Colorado approach for adverse parties. Suba-Jenki creates agency under another broker's client, and power of attorney is a separate legal authorization. Question 6. A buyer asks Parker Patel to negotiate solely in the buyer's best interest. What must exist before the broker acts as the buyer's advocate? Option A, an automatic transaction-broker relationship with no written agreement. Option B, a title commitment issued by the closing company. Option C, a written single-agent brokerage relationship with the buyer. Option D, a verbal promise that the broker will try hard. The correct answer is option C, A written single-agent brokerage relationship with the buyer. Advocacy for one party requires an agency relationship created through the proper brokerage agreement. A transaction-broker does not advocate, title commitments address title issues, and a verbal promise is not enough to define agency duties. Question 7. Cameron Lane, a licensed broker, wants to buy a mixed-use property personally. What disclosure is most important to make to the seller? Option A. The broker's favorite lender even when no loan is involved. Option B. The broker's private tax return history. Option C. The names of every buyer who toured the property. Option D. The broker's licensed status and personal interest in the transaction. The correct answer is option D. The broker's licensed status and personal interest in the transaction. A licensee buying or selling for personal benefit should disclose licensed status and personal interest. Preferred lenders, tax records, and prior showings do not address the conflict created by a broker acting as a principal. Question 8. Avery Quinn receives a $7,500 earnest money check for a mountain cabin contract. Where should funds belonging to others be placed? Option A. In the appropriate trust or escrow account according to the contract and brokerage procedures. Option B. In the broker's personal checking account until inspection is over. Option C. In the brokerage marketing account for advertising expenses. Option D. In a cash envelope kept at the property until closing. The correct answer is option A. In the appropriate trust or escrow account according to the contract and brokerage procedures. Money belonging to others must be safeguarded through the proper trust or escrow arrangement and documented. Personal accounts create commingling, marketing accounts are for business expenses, and cash envelopes do not provide acceptable accounting controls.
Are you looking for TSN exam actual questions? Visit our website pokerexams.com to access TSN exam study guide with actual questions and answers. Scan the QR code or click the link in the description to get TSN exam answer key today.
Question 9. A buyer and seller both demand the same $8,175 earnest money after a failed contingency. How should the broker holding the funds respond? Option A. Or release it to whichever party calls first. Option B. Do not release the money unilaterally, follow the contract, written mutual instructions, or a proper legal process. Option C. Keep it permanently as brokerage income. Option D. Is split it personally without telling either party. The correct answer is option B. Do not release the money unilaterally, follow the contract, written mutual instructions, or a proper legal process. Disputed earnest money should not be released without proper authority. First contact does not decide entitlement, disputed deposits are not brokerage income, and a personal split would violate the duty to account for funds. Question 10. Emerson Rivera posts a video ad for a listing in Durango but omits the brokerage name. Which advertising issue is most likely? Option A. The ad automatically transfers title to the viewer. Option B. The ad creates a mortgage lien on the property. Option C. The ad may be misleading because it does not clearly identify the brokerage behind the advertisement. Option D. The ad removes the need for a written listing agreement. The correct answer is option C. The ad may be misleading because it does not clearly identify the brokerage behind the advertisement. Real estate advertising should be truthful and identify brokerage involvement clearly. An ad does not transfer title, does not create a mortgage lien, and does not replace a proper written listing agreement. Question 11. A seller asks Morgan Nash to charge the same commission rate as every other brokerage in town. Which antitrust concern should the broker avoid? Option A. Explaining the broker's own office fee policy. Option B. Negotiating compensation in a listing agreement. Option C. Telling the seller that commissions are negotiable. Option D. Suggesting that commission rates are fixed or agreed upon by competing brokers. The correct answer is option D. Suggesting that commission rates are fixed or agreed upon by competing brokers. Antitrust law prohibits price fixing and agreements among competitors on commission rates. A broker may explain that broker's own fee policy, negotiate compensation, and tell the seller that commissions are negotiable. Question 12. A buyer asks Reese Stone to draft custom legal language giving unusual post-closing rights in a townhome. What should the broker do? Option A. Use approved forms when appropriate and refer custom legal language to an attorney. Option B, a draft any clause requested because brokers may practice law during sales. Option C, refuse to use any written contract for unusual terms. Option D, ask the title company to sign the clause for the buyer. The correct answer is option A. Use approved forms when appropriate and refer custom legal language to an attorney. Colorado brokers may use approved forms within their authorized role, but custom legal drafting should be handled by legal counsel. Brokers are not authorized to practice law for clients, unusual terms still need written documentation, and title companies do not sign contract clauses for buyers. Question 13. Finley Ortiz signs a listing agreement for an office suite but leaves the termination date blank. Why is that a problem? Option A. A blank date automatically makes the listing valid for 10 years. Option B. Listing agreements should have a definite termination date rather than continuing indefinitely. Option C. Termination dates are required only for commercial leases. Option D. The county assessor supplies the date after signing. The correct answer is option B. Listing agreements should have a definite termination date rather than continuing indefinitely. A definite termination date defines the broker's authority and avoids an open-ended listing. A blank date does not create a 10-year term. The issue is not limited to commercial leases, and assessors do not complete listing agreements. Question 14. In Jordan Turner's contract for a residential acreage, the inspection objection deadline passes without notice from the buyer. Why does that deadline matter? Option A. Deadlines are only reminders and never affect rights. Option B. All deadlines are set later by the county recorder. Option C. Contract deadlines control when a party must act to preserve specific rights or contingencies. Option D. The broker may extend deadlines alone whenever it seems fair. The correct answer is option C. Contract deadlines control when a party must act to preserve specific rights or contingencies. Colorado contracts use deadlines to define when objections, notices, and terminations must occur. They are not casual reminders. County recorders do not set private contract deadlines, and brokers cannot unilaterally extend deadlines for the parties. Question 15. Skylar Price reviews closing instructions for a Longmont sale. What is the primary purpose of those instructions? Option A. To replace the purchase contract with a verbal agreement. Option B. To create a new property tax assessment for the county. Option C. To authorize the broker to practice law for the parties. Option D. To direct the closing company on documents, funds, preparations, and conditions needed to close. The correct answer is option D. To direct the closing company on documents, funds, preparations, and conditions needed to close. Closing instructions coordinate how the closing company handles documents, money, preparations, and closing conditions. They do not replace the purchase contract, set tax assessments, or expand a broker's authority to provide legal services. Question 16. Harper Underwood asks when ownership of a small warehouse is transferred by deed. Which event is essential? Option A. A delivery and acceptance of a valid deed. Option B. A printing a marketing flyer for the property. Option C. A receiving a verbal value estimate from an appraiser. Option D. Ordering a home warranty before closing. The correct answer is option A. Delivery and acceptance of a valid deed. A deed transfers ownership when it is validly delivered and accepted. Marketing, appraisals, and warranties may support the transaction but do not themselves convey title. Question 17. Taylor Adams finances a Colorado purchase with a $242,500 loan. Which document is the borrower's promise to repay the debt? Option A. Warranty deed. Option B. Promissory note. Option C. A settlement statement. Option D. Listing contract. The correct answer is option B. Promissory note. The promissory note is the borrower's personal promise to repay the loan. A warranty deed conveys title, a settlement statement accounts for closing charges, and a listing contract creates a brokerage relationship with a seller. Question 18. Drew Vega is selling a suburban rental house with irrigation water rights near Thornton. Which Colorado principle is most closely tied to priority of water use? Option A. Automatic ownership of all underground water by the newest buyer. Option B. Equal monthly sharing among all neighboring parcels regardless of priority. Option C. Prior appropriation, often summarized as first in time, first in right. Option D. Federal flood insurance rules controlling every water diversion. The correct answer is option C. Prior appropriation, often summarized as first in time, first in right. Colorado water rights are closely associated with prior appropriation and priority of beneficial use. New buyers do not automatically own all underground water, neighbors do not share equally regardless of priority, and flood insurance rules do not determine water minus right priority.
Stressed about your TSN exam? We can take TSN exam for you remotely and undetected. We always guarantee a pass and payments only after results. To send us an email, scan the code or tap the link in the description and let's get it done.
Question 19. A landlord tells Logan Brooks not to show a Broomfield rental to applicants with children. Which law topic should the broker recognize immediately? Option A. A legal occupancy preference that overrides federal law. Option B. A zoning setback requirement. Option C. A title insurance exclusion. Option D. A familial status discrimination under fair housing law. The correct answer is option D. Familial status discrimination under fair housing law. Refusing applicants because they have children raises familial status discrimination concerns. Zoning setbacks involve land use, title exclusions involve ownership risks, and a landlord preference does not override fair housing requirements. Question 20. Riley Walker manages a rental in Pueblo and collects a $2,080 security deposit. Which responsibility is most important? Option A is safeguard and account for tenant funds according to lease terms, trust rules, and applicable law. Option B, use the deposit for brokerage advertising as soon as it is collected. Option C, treat the deposit as earned commission immediately. Option D, record the deposit as a deed in county land records. The correct answer is option A. Safeguard and account for tenant funds according to lease terms, trust rules, and applicable law. Tenant funds and security deposits must be safeguarded and accounted for properly. They are not advertising money, they are not automatically earned commission, and they are not recorded as deeds. Question 21. A home built in 1953 is offered for sale, and Jamie Carter is preparing disclosures. Which federal disclosure topic should be remembered if the home was built before 1978? Option A. New minus construction warranty registration only. Option B. Lead minus based paint disclosure requirements. Option C. Commercial securities prospectus delivery. Option D. A flood insurance disclosure only because the home is older. The correct answer is option B. Lead minus based paint disclosure requirements. Residential property built before 1978 triggers federal lead minus based paint disclosure requirements. New minus construction warranties involve a different issue. Securities prospectuses are unrelated to ordinary residential sales, and flood insurance is not based only on the age of the home. Question 22. Marlo Sue buys a property for $275,000 with a 90% loan minus to minus value loan. How much is the buyer's down payment before other closing costs? Option A, $247,500. Option B, $13,750. Option C, $27,500. Option D, $302,500. The correct answer is option C, $27,500. A 90% loan means the lender finances $247,500, leaving $27,500 as the down payment before separate costs. The loan amount is not the down payment, 5% does not match the stated ratio, and adding the down payment to the price double minus counts the obligation. Question 23. An investor asks Casey Diaz to estimate value for a rental producing $102,000 net operating income at a 7.5% capitalization rate. What value is indicated? Option A, $7,650. Option B, $102,075. Option C, $136,000. Option D, $1,360,000. The correct answer is option D, $1,360,000. Income capitalization divides net operating income by the capitalization rate, so $102,000 divided by 0.075 indicates about $1,360,000. Multiplying by the rate gives only a small fraction of income, adding the rate as dollars is meaningless, and dividing by 10 times the rate understates value. Question 24. Using a 360-day proration year, annual property taxes are $4,560, and the seller is responsible for 34 days. What tax debit should be charged to the seller? Option A, $431. Option B, $4,526. Option C, $380. Option D, $425. The correct answer is option A, $431. With a 360-day year, the daily rate is $4,560 divided by 360 and then multiplied by 34 days, which rounds to $431. Subtracting days from dollars is not a proration. 1 month of taxes ignores the stated days, and using 365 days does not follow the instruction. Question 25. Sage Ellis notices inconsistent square footage figures for a duplex in Denver. What is the best professional response? Option A, choose the largest figure because it helps marketing. Option B, disclose the uncertainty and recommend that the parties verify measurements through reliable sources. Option C, hide all square footage information from the buyer. Option D, guarantee the number without reviewing any records. The correct answer is option B. Disclose the uncertainty and recommend that the parties verify measurements through reliable sources. Conflicting measurements should be handled with disclosure, caution, and verification. Choosing the largest number can mislead buyers, hiding information does not solve the problem, and guaranteeing an unverified figure creates unnecessary liability.